Hello and welcome back. My name is Soumya Uma. I work as Assistant Professor in Maharashtra National Law University, Mumbai. In the first two modules on juvenile justice, we discussed the Indian legal developments on juvenile justice. In the present and the next module, we will discuss international standards on juvenile justice and how they apply to India. The objectives of Module 3 that we are going to discuss now are 1. To have an overview of the international concern for juvenile justice. 2. To understand the relevance of various international standards on juvenile justice. 3. To obtain an in-depth understanding of the concepts and important standards. The structure of the module will be in this manner. We will begin with examining the international concern for juvenile justice. Then we will look at the provisions of the International Covenant on Civil and Political Rights, of which India is a state party. Then we examine the UN minimum standard, which is called the Beijing Rules 1985. After that, we will try and understand the primary international convention on child rights, which is the UN Convention on Child Rights, of which India is a state party. Finally, we will look at the general comment number 10 of the Committee on Child Rights. By discussing the various provisions in international standards, we will understand the basic principles evolved, which can provide guidance to domestic lawmaking processes on the issue of juvenile justice. So first, let us begin with the international concern for juvenile justice. The issue of administration of juvenile justice, and in particular the standards and procedures relating to deprivation of the liberty of juveniles, has received increasing interest and focus in various sectors of the United Nations. These include adopting various conventions, declarations, recommendations, general comments, guidelines and standards. Countries as well as NGOs, that is non-governmental organizations, have endorsed these standards. These standard setting mechanisms have extreme relevance and practical application to all regions of the world, including India. Some such standards have binding nature, leading to an obligation on the government to comply with the same. Others have persuasive value and can influence and shape the formulation of laws and rules within the country. We will be looking at both the conventions which are binding as well as the rules which are persuasive in nature. So let's start with the International Covenant on Civil and Political Rights 1966. This is called the ICCPR. One of the earliest references to a rights-based approach on juvenile justice can be found in this ICCPR, which was adopted in the year 1966. It incorporates important and fundamental principles related to juvenile justice. In Article 6, Subclause 5, for example, the covenant prohibits imposition of death penalty on persons below 18 years of age and provides for separation of juveniles from adult offenders, as well as speedy trial for juveniles, treatment of juvenile offenders according to age and legal status, as well as the requirement that trial procedures for juveniles should incorporate promotion of rehabilitation. Now let us next look at the UN standards minimum rules for the administration of juvenile justice. These are called the Beijing Rules, and they were adopted in 1985. In 1985, the UN General Assembly adopted these standard minimum rules for administration of juvenile justice. From now on, I will be referring to them as the Beijing Rules. These came to be known as the Beijing Rules as they were elaborated by the Preparatory Interregional Assembly for the 7th Congress about Youth, Crime and Justice, which took place in Beijing, China in 1984, and they were subsequently adopted by the General Assembly in the next year. Now let us try and understand the significance of the Beijing rules. Firstly, the rules have taken into consideration and respect various national legal frameworks, structures and systems. Across the world, for example, juveniles are treated and dealt with variedly by family courts, criminal courts and administrative courts. The Beijing rules looked at all of these. These rules form part of the minimum standards and conditions that are presently applicable at the international level for the treatment of children and adolescents who are in conflict with the law. Though the Beijing rules are not binding on states, what they do is that they provide comprehensive guarantees to protection of juveniles in all stages and phases of the criminal justice process. The rules guide each country to protect the rights of children who are alleged to or who are found to have committed an offense, and they help to develop a separate system of juvenile justice which would run parallel to the criminal justice system in the country for adult offenders. Next, they encourage appropriate community programs as alternatives to formal court hearings. The Beijing rules broke new ground by encouraging alternatives to judicial processes and by stipulating that detention should be as a last resort and for the shortest possible time. They reiterate the importance of rehabilitation and reformation as opposed to incarceration or punishment through a retributive or deterrent approach, as well as they have built-in forms of assistance such as education, employment and shelter for children and for juveniles. The rules signify the tension and dilemmas that existed between rehabilitation and what is known as jus deserts, that is retribution or appropriate punishment. So between rehabilitation on one hand and punishment on the other hand. The rules further try to strike a fine balance between assistance to the juvenile versus repression and punishment. Protection of the welfare of the juvenile versus protection of the society in general, and also institutional versus non-institutional treatment. Now let me highlight to you the salient features of the Beijing rules. Firstly, definition of the juvenile offender. The rules define a juvenile offender as a child or a young person who is alleged to have committed or who has been found to have committed an offense. Secondly, age of criminal responsibility. The age of criminal responsibility is the age above which the child will be held responsible for the offense that he or she is alleged to have committed or found to have committed. The Beijing rules, interestingly, do not fix the age, and they allow discretion to each country to fix the same. However, the rules caution countries from fixing the age too low, keeping in consideration factors such as emotional, mental and intellectual maturity of the child. Thirdly, the aims of the juvenile justice system. The rules state twofold aims. Firstly, promoting the welfare of juveniles, and secondly, encouraging states to respond to juvenile delinquents in a manner that is proportional to the offense committed as well as the context in which the juvenile committed the same. The first aspect indicates a welfare-based as opposed to a rights-based approach. We discussed these two approaches in the last module. The second aspect deals with what is known as the principle of proportionality. This principle is used to curb the use of excessive criminal and punitive sanctions against children. What the Beijing rules also deal with is the scope of discretion. Personnel associated with the juvenile justice system enjoy wide discretion during all the phases of administration of juvenile justice. These phases include investigation, prosecution, adjudication, and thereafter. So the Beijing rules have specifically ensured that the special needs of juveniles as well as the measures available which widely vary, these are taken into consideration. In this context, the Beijing rules emphasize sufficient accountability of the actors involved and specific and special qualifications, including training of the personnel who exercise such discretion. This is to ensure that the discretion is exercised in a proper manner. These rules are aimed at making the administration of juvenile justice fair and humane. What the Beijing rules also deal with are the rights of juveniles. The rules spell out basic fair trial guarantees and fundamental procedural safeguards such as the presumption of innocence, the right to be notified of the charges, the right to remain silent, the right to seek the professional services of a lawyer, the right to the presence of a parent or a guardian during the proceedings, the right to confront and cross-examine witnesses, and the right to appeal to the higher authority. These are rights which are to be guaranteed at all stages of the proceedings. The importance of protecting the juvenile's right to privacy has also been emphasized in the Beijing rules. This rule emerges from the fact that labeling a juvenile as a criminal or giving undue and adverse publicity may lead to stigmatization of that particular juvenile. Such measures would not only be counterproductive but also detrimental to the development of the juvenile to his or her fullest potential. What the Beijing rules also talk about is prohibition of capital and corporal punishment. The adjudication and disposition section of the rules clearly prohibit the imposition of capital as well as corporal punishment on juveniles. The prohibition of capital punishment is in consonance with Article 6, Clause 5 of the ICCPR, which we have already discussed in the beginning of this module. While the provision against corporal punishment is in conformity with Article 7 of the ICCPR, and this is further reiterated in another UN convention, that is the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, as well as the UN Convention on the Rights of the Child. The Beijing rules also insist on the least possible use of institutionalization. The rules very clearly state that institutionalization shall only be a measure of last resort and for the minimum possible duration. The Beijing rules do not exclude the possibility of institutional treatment. This is something that we have to be clear about. However, the preference for non-institutional interventions is in conformity with progressive criminology that prioritizes non-institutional treatment and interventions over institutional ones. This is for various reasons. Institutionalization leads to a deprivation of liberty and it removes the juvenile from the surrounding that he or she is familiar with or accustomed to. Further, institutionalization can lead to negative influences on the juvenile. Additionally, no substantial benefits have been recorded through institutional treatment. The Beijing rules also apply standards during institutional treatment. The Beijing rules further state that in situations where the juvenile is kept in an institution, either pending adjudication or subsequent to the conclusion of adjudication, the standard minimum rules for the treatment of prisoners adopted by the United Nations shall be applicable. So, in all such situations, the UN standard will be applicable. Some important and fundamental aspects of protection pertaining to juveniles in conflict with the law, which are detailed in institutions contained in the standard minimum rules. These include aspects such as accommodation, architecture of the institution, bedding that is provided, clothing that is provided, complaints and requests from the juvenile, contact with the outside world, food and medical care which should be available, religious service which should be allowed, separation of ages, separation as per ages of the juveniles, staffing, work, punishment, discipline and restraint for dangerous offenders. The rules emphasize the principle of best interest of the child during all proceedings conducted by state appointed authorities. The Beijing rules also underline the importance of specialized capacity building programs for all the authorities who are part of the juvenile justice system. This is so that they can become sensitive and they can provide humane services while working with the juvenile justice system. They promote each country to conduct scientific research on juvenile justice as a basis upon which laws, policies, programs and interventions may be effectively formulated at the state level. So, scientific research is very, very important. They also call upon various civil society actors such as volunteers, NGOs and local institutions to assist the rehabilitation of the juvenile. The rules are divided into 6 parts, namely general principles, investigation and prosecution, thirdly adjudication and disposition, fourthly non-institutional treatment, fifthly institutional treatment and sixthly research, policy formulation and evaluation. Each of the 6 parts has associated rules. I would suggest that you look at the Beijing rules and read the original text for further details and for a better understanding of the provisions of these standards. Now let's look at one of the most important conventions and international standard, that is the UN Convention on the Rights of the Child 1989. The UN Convention on the Rights of the Child, which is known as CRC, was adopted by the General Assembly in 1989. It provides a comprehensive framework for administration of juvenile justice. It incorporates standards set in the Beijing rules as well as the ICCPR, both of which we have already discussed, and it gives further detailed guarantees within the overall perspective of 4 founding principles. 1. Right to life, survival and development, which is stated in Article 6. 2. Best interest of the child, which is stated in Article 3. Third, right to participation, which is stated in Article 12. And fourth, right to protection. The CRC defines children as persons below 18 years of age. In addition to the more general provisions on child rights, what is important for us to look at are Articles 37 and Articles 40. These deal very specifically with aspects of children in conflict with the law. The text of these two provisions is given in your notes, so I will not be reading out these provisions to you, but you can refer to the notes to read the original text. Let me summarize what these two provisions talk about. Article 37 reiterates the principle that children cannot be arrested, detained, or imprisoned without warrant, that governments are under an obligation to ensure that children who are in conflict with the law are not subjected to torture or other inhumane forms of treatment or punishment. This particular article also emphasizes the need to segregate children in conflict with the law from adult offenders when both of them are institutionalized. Other basic rights such as the right to remain in contact with their families, the right to have a lawyer, the right to appeal their stay in prison, these are also stated in Article 37. Look at Article 37 and you will see all these rights which are stated there. Now let us focus on Article 40. Let me summarize Article 40's contents for you. Article 40 focuses on aspects of due process of the law and fair trial guarantees. This includes 1. The right to be presumed innocent until proven guilty. 2. The right to legal assistance. 3. The right to a trial. 4. Freedom from being compelled to testify or enter a guilty plea. Article 40 reiterates the responsibility of governments to fix a minimum age of criminal responsibility. So, Article 40 once again does not fix the age of criminal responsibility. This is left to the discretion of every state, every country to do so. Fundamental principles for treatment of a juvenile in conflict with the law, which are stated in the UN Convention on the Rights of the Child, that is the CRC. So, let us look at some of these fundamental principles. First principle, treatment should be consistent with the child's sense of dignity and worth. Second principle, treatment should enforce or reinforce the child's respect for the human rights and freedoms of others. Third principle, treatment should take into account the child's age and promote the child's reintegration, and also it should look at the child assuming a constructive role in society. And the fourth principle, respect for the dignity of the child, requires that all forms of violence in the treatment of children in conflict with the law must be prohibited as well as prevented. Based on these principles, the CRC guarantees the juvenile a right against torture, inhuman or degrading treatment, right against capital punishment, and a right against life imprisonment. It prohibits unlawful arrest and arbitrary deprivation of liberty of juveniles, reiterating the standards which have already been set by the Beijing rules that imprisonment should be as a last resort and for the shortest possible period of time. Various conditions have been laid down related to arrest, detention and imprisonment, including separation from adult offenders while in custody, access to legal assistance, speedy trial and right to remain in contact with the family. The CRC also provides alternative measures to judicial proceedings for juveniles who violate criminal law. It calls upon states to establish and promote distinctive juvenile justice mechanisms with a special and specific emphasis on positive rather than punitive aims. This includes institutional care for rehabilitation and reintegration in society. This is again a difference between the approach to juvenile justice and the approach to criminal justice that is available for adults. Here the focus is very specifically on rehabilitation and reintegration into society. In addition to the rights of children in conflict with the law, the CRC in Article 39 also addresses issues of children who are victims of neglect, abuse and exploitation, and their rehabilitation and reintegration with mainstream society. The relevant article reads as follows: States parties shall take all appropriate measures to promote physical and psychological recovery and social integration of a child victim of any form of neglect, exploitation or abuse, torture or any form of cruel, inhuman or degrading treatment or punishment, or armed conflicts. Such recovery and reintegration shall take place in an environment which fosters the health, self-respect and dignity of the child. The provisions of the CRC have improved children's well-being and the standards by which juveniles are treated by the law throughout the world. The provisions have challenged the way in which governments and citizens view and prioritize juvenile justice in their laws, policies, programs and interventions. Those state parties that have ratified the CRC are obliged to bring home the international standards and to implement the provisions of the CRC in domestic law. This has led to various governments amending their national constitutions as well as their domestic laws, rules, policies and programs pertaining to juvenile justice. In compliance with the CRC provisions, for example, Peru in 1993, Italy in 1994, Malawi in 1995, Kazakhstan and Poland in 1997, Morocco in 1999 and Kenya in 2001 and subsequently Mali in 2002 abolished the provision of sentencing children for life imprisonment without parole. Yemen in 1994 and Mali in 2002 established 18 years as the age of criminal responsibility. Trinidad and Tobago in 2000 revised the definition of young person from an individual under the age of 16 to a person under 18 years of age. India too has amended its law on juvenile justice in 2000, 2006 and 2015 in order to discharge its obligations after it ratified the CRC and it became a state party. So domestic law could be brought in conformity with international standards. We have discussed this in the last module. Now let us move on to the last aspect of this particular module, that is, we look at the general comment number 10 of the UN Committee on Rights of the Child. This general comment was given in the year 2007. In 2007, the UN Committee on Child Rights in General Comment 10, which was titled Children's Rights in Juvenile Justice, has elaborated further on the provisions of the provisions that have been found in the CRC. Why was this done? This was done in the light of its review of state parties' performance on juvenile justice. The committee stated and elaborated upon the leading principles as well as core elements of comprehensive policy on juvenile justice. So let me summarize these for you. So firstly, let us look at the leading principles of a comprehensive policy on juvenile justice. The committee highlighted and elaborated upon 5 leading principles stated in the CRC. These 5 leading principles are as follows. These have been given in your notes in Matrix 1. First principle is non-discrimination, Article 2. The non-discrimination principle has several facets in its application to the domestic administration of juvenile justice. Firstly, the state parties are obliged to treat all juveniles equally and without any discrimination on any ground whatsoever, such as sex, religion, race, nationality, etc. Secondly, the committee noted that many children in conflict with the law are also victims of discrimination, such as in accessing education or in the labor market. Hence, it is important that measures are taken to prevent such discrimination. Thirdly, the non-discrimination principle is also applicable in ensuring that any conduct which is not considered as an offence and it is not penalized if committed by an adult is also not considered an offence and not penalized when it is committed by a young person. Such conduct includes vagrancy, truancy, roaming the streets, runaways, etc. Since such behavior is often a result of psychological or socio-economic problems, the committee suggests that criminalization would not be a useful approach. Second principle, best interest of the child. This is enshrined in Article 3. This principle is arguably the most important principle in relation to child rights. The committee explained this in the context of juvenile justice in the following words. It said, in all decisions taken within the context of the administration of juvenile justice, the best interest of the child should be a primary consideration. Children differ from adults in their physical and psychological development and in their emotional and educational needs. Such differences constitute the basis for the lesser culpability of children in conflict with the law. These and other differences are the reasons for a separate juvenile justice system, and this is why a different kind of treatment is required for children. The protection of the best interest of the child means, for example, that the traditional objectives of criminal justice such as repression, retribution, these must give way to rehabilitation and restorative justice objectives in dealing with child offenders. This can be done in concern with the attention to effective public safety. The right to life and survival as well as development is a right which is there in Article 6. The inherent right to life, survival and development of every child is intended to guide and motivate states parties when they formulate laws, policies, programs and schemes for intervention on the issue of juvenile justice. This right consequently prohibits the imposition of death penalty as well as life imprisonment without parole. The committee was extremely conscious of the fact that a deprivation of life and liberty of the child has extremely negative consequences for the child's own development as well as for reintegration with society. Next, the right to be heard, Article 12. The child's right to express his or her wishes, desires and opinions in all matters concerning the child was established in the CRC. This has been emphasized in the General Comment number 10. This right is of particular importance in India, where culturally age-related hierarchies cause obstacles to child participation in the proceedings and a presumption that adults will take all decisions on behalf of the concerned children without hearing the voice of the concerned children themselves. Next, the right to dignity, which was dealt with in Article 40 of the CRC. The right to dignity is a core human right. In the context of juvenile justice, the following aspects have been highlighted in the general comment. 1. Treatment that is consistent with the child's sense of dignity and worth. 2. Treatment that reinforces the child's respect for the human rights and freedoms of others. 3. Treatment that takes into account the child's age and promotes the child's reintegration and the child's assuming a constructive role in society. And 4. Respect for the dignity of the child that requires that all forms of violence in the treatment of children in conflict with the law must be prohibited and prevented. Let us lastly look at the core elements of a comprehensive policy on juvenile justice. In addition to the leading principles which we have discussed just now, General Comment number 10 also discusses core elements of comprehensive policy. These are elements that states should focus upon when they formulate their comprehensive policy on juvenile justice. So let's look at these principles for a comprehensive policy on juvenile justice. Firstly, prevention of juvenile delinquency. This is one of the core concerns of a policy on juvenile justice. That is to ensure that not only is rehabilitation taken care of, but also prevention in the first place. While emphasizing the responsibility of parents at ensuring prevention, the committee also notes the need for assistance to be provided to parents and caregivers in this regard. So it is the state, the parents and the caregivers who have a responsibility of prevention. Next principle, interventions and diversions. The committee identified two kinds of interventions or diversions. Interventions without resorting to judicial proceedings and measures in the context of judicial proceedings. In the latter, it emphasized the judicial proceedings should be initiated by a competent authority and all aspects of fair trial should be followed. These are given in further detail in your notes, so please refer to your notes to understand this principle much more. Now let us move on to the next principle. So, the committee suggested a variety of community-based programs which have been developed, such as community service, supervision and guidance, for example by social workers or probation officers, family conferencing and other forms of restorative justice, including restitution to and compensation of victims. Other states' parties should benefit from these experiences. This is what the committee has said. The committee also spoke about minimum age of criminal responsibility, which is very, very important. The committee's observations on the age of criminal responsibility arise from its work on the field, and it complements the Beijing rules, which is rule number 4, and the provisions of CRC, which have been discussed a little earlier. So please look at this in your notes that gives further details of aspects related to minimum age of criminal responsibility. The committee's observations on the age of criminal responsibility arise from its work on the field, and this complements the Beijing rules as well as the provisions of CRC which we have just now discussed. It is said that across various countries, the minimum age of criminal responsibility has varied from a very low 7 to 8 years to a commendably high 14 to 16 years. Article 40, Clause 3 of the CRC mandates state parties to prescribe a minimum age of criminal responsibility. Below this minimum age of criminal responsibility, there will be a legal presumption that the child is incapable of violating the penal law. The CRC, once again, like the Beijing rules, does not specify a minimum age. The committee in General Comment 10 provides guidelines to the state parties on how to arrive at a minimum age of criminal responsibility and what factors should be considered before setting the minimum age. Those children who are above the minimum age of criminal responsibility but below the age of 18 can be formally charged and subjected to judicial proceedings. However, such proceedings will be governed by the principles and provisions of the CRC as elaborated in General Comment 10. The committee states that the minimum age should not be set at lower than 12 and should continue to increase it to a higher age level with due consideration to all aspects of emotional, mental and intellectual maturity. There are also other core principles which are discussed in your notes, such as the guarantees for a fair trial and some other core principles as well. Please refer to your notes for further details and elaboration on these aspects. With this, we come to the end of module number 3, which is on international standards relating to juvenile justice. As I have said in the past modules, this particular discussion that we have had is only a small overview. However, for you to develop better insights and a deeper knowledge of this issue, you must look at the notes, you must look at the references which have been given along with the notes, and you must also look at the original text of these international standards and read that, so that that will give you a more holistic perspective on this. With that, we end this module. Thank you.